that will make a contract not to be enforced, despite the fact that that contract has all the elements. And there are many of such factors. It could be by way of mistake or misrepresentation, or it could be undue influence, it could be duress, where someone is coerced to enter into a contract, and all of those ones. So, but the one we're looking at is illegality. That is a contract that is illegal against the provisions of law, and the consequence of which such contract is void or unknown to law. Now, of course, the courts, as I said, and someone should read the first paragraph just to know that we're all together. Someone should read the first paragraph to know we're all together.
Court will not enforce an illegal and void contract based on three grounds: unwillingness to aid such contract, justice will be tainted, and the dignity of the court offended by such intervention. And
Okay,
the third one is need to discourage illegal enterprises.
thank you. So, there are two things here. One, a contract that's illegal. Illegal, if you take IL, well, that IL is a prefix. You can take it away, and what you have is legal. So, what is legal is what is enforceable. Then, if IL to it becomes illegal, it means that that action or that contract, either by way of it forming it or by way of performing that contract, it is illegal. It's against the provision of law because it's either prohibited by law or forbidden by law, as the case may be. You know, and of course, when you say that a contract is void, on the other hand, it means that that contract has no legal effect. That is, in other words, before the courts, there is no legal relationship at all. It has no legal effect, before the court. Now, so that's what we're going to look at. A contract that you know is against the provision or is prohibited by law. The consequence of which is that such contract is unknown, and of course is void, and of course is unenforceable. So we're looking at that. That's the point that we're looking at here. So let's start with the first aspect of it, which is illegal. Now, of course, before that, yes, there are some justification why the court cannot, enforce an illegal contract. One is the unwillingness to aid such contracts. Remember that I will discuss a scenario Williams and Everest and Williams, where criminals had agreement with respect to robbing a bank. After which they will share the proceeds, and one of them went to the court to argue that his proceeds were not given to him, right? So if the court was willing to promote such activities, it means that people will just go in doing into so many illegal contracts, as case may be. That means that the law will no longer be at the center, but illegality will take the place, as the case may be. Now, also because of the dignity and dignity of the court, because it will be tainted with injustice and people will be there won't be public interest, public trust anymore. Of course, also we have the issue of the need to discourage people from embarking on illegal transaction, only to go to court and seek stamp or what is illegal. So a contract is considered illegal when the subject matter of the agreement violates the law or it's contrary to public policy. Now, so for every contract, there's always a subject matter. There's that central thing that the terms of agreement are built on. The purpose of going to that contract, you know, between you, student, and University of Lagos, for instance, the purpose of the why you have offer or admission and you accepted and all of those stuff is all about certificate. What do you need is certificate, nothing more than that. That's the subject matter, you know. So it then means that if you can go to Shomolu, anybody can because the certificate is printed. Instead of going to Shomolu to get certificate, someone can print certificate and give to you. They will sign beautiful and give you. But you see that that's will be illegality. So you cannot parade yourself with such certificate that you print from Chomolo and you stamp. So what do? You come to where things are done regularly. So for University of Lagos, certificate is subject matter. You know, if you live in University of Lagos, you can go outside of it. Many other subject matter. It could be purchase of car, purchase of house, renting of office space, supply of goods, importation, clearance, banking, so employer, employee, so many contracts. There's always a subject matter. So we're saying that if that subject matter violates the law or is contrary to public policy, so for every country or every business, there are laws that regulate that business. So if you enter into a contract, either by way of performing that contract or at the time of performing that contract, it violates the laws of the land. Such contract will be clearly regarded as illegal contracts, right? So there are many of such examples of illegal contracts, where it is expressly prohibited by law or where is it regulates dealings in a particular trade, I mean profession, you know, and of course where it is for the public interest, that which is acceptable, are being for interest of the public. So it could be illegal at the time of formation or at the time of performing the contract, whichever way. Um, Illegal contracts are not, you know, enforceable, even though they have elements of offer acceptance, consideration, and all of those ones. But because they're illegal, they're against the extant laws or they're prohibited by law. Such contract are not enforceable. And there are examples of it here: committing a murder. You know, like someone was saying in politics, toggery in politics, where you can enter into a contract you're giving thugs some money to go and beat your opponent. Now the thugs collected money from you, but refuse to go and beat. Oh, they went there, but instead of beating the opponent, they didn't beat up the opponent or even assassinate the opponent. They didn't do that. Now here you are now. You are suing that. You now sue that murderer, that thug that you hired for breach of contract. And they will ask, what's the subject matter of the contract? Oh, I gave him or her money to go and beat and kill my opponent, but he didn't do it, so they should refund you your money. Imagine what the court will say to you. Sale of drugs that are prohibited by the laws of the land, drugs that NAFDAC has prohibited sale. You are entering into a contract for supply of such drugs. I mean, drugs. Prohibition, I mean, prostitution and gambling. Also, you know, hiring of underage workers, someone less than 16 years, and the purpose of hiring that person is not for apprenticeship or learning and skills, but it's in the context of normal work. All of those ones are prohibited. They are just examples of illegal contract. Now, where a contract is illegal, the consequences is that it's void ab initio, subject to certain exception. This void that means that when you say that when something is void ab initio, it means that at the beginning, at the time that offer and acceptance was made, it's deemed that there was no contract as at that time, you know, because you can't build something on nothing. Since we're saying that illegality is not accepted by law, you cannot claim that you have entered into a contract for something that is not recognized, by law. You know, and of course, the magazine as we say the ex supu causa non orito action. No action can arise from a base cause. You know, a base because nothing is there. Because in the eyes of law, the contract is legal, and illegal contract is deemed not to exist. So you cannot build anything on it. So that's why it's called void. The contract is void at the initial stage of that contract is deemed to be void. You know, and of course there are some defenses to illegality. You can see them um, uh, there. In action to recover a bribe of a car and £7,500 to a government official. Faith. You are bribe a government official for whatever project, and that will not give it. You want to sue that government should recover that bribe for you that giving. You know, cannot. Arm robber, who sue a partner. That's the case I was discussing with you. Everett and Williams, the case I was discussing with you, with respect to the fact that you know they went to court to yes, and someone can Google that case, Everett and Williams. The facts are there, but just someone can Google it. I'll come back to ask you all. But it was just a case of armed robbers who agreed to rob a bank and share. They agree on the sharing formula. But what they did was that um, when they did the robbery successful and came back to share the proceeds, one of them felt that he was cheated, so he went to court. You know, he went to court to that the court should compare those other co-criminals to pay him his exact share. You know, the solicitor, the lawyer that went there to represent him was heavily fined, and of course, all of them that went to court, all those armed robbers were also executed. They arrested them and executed all of them. You know, so the it's also that's for illegal contracts, and for void contracts. I said the when the contract is void, the law will disregard it because it will not be recognized as capable of giving rights to any right or liability for the reason of public policy. Now you remember that look, the whole essence of contract. If you look at if you remember the area of you know um, formation of contracts, that is at the time of offer and acceptance, we made mention of the fact that the terms of contracts start building. When offer is made. You know when offer is made, that is when you know the terms of contract start building. So what exactly are the terms of contract? What the effect of terms of contract is that they create rights, they create obligations, they create duties. So parties, when you say you are performing contract, you're just carrying out your own obligations under a contract. And I keep giving example of the student and University of Lagos, for instance. The University of Lagos is the one that enter into agreement with you. I'm not the one. But because University of Lagos has to perform its own obligation, they have hired me to perform that obligation on behalf of the University of Lagos. And that's why you will not see my name in your certificate. You will not see the name of any of your lecturers in your certificate. You just see that it's issued by University of Lagos. But then, because of that contract that you enter with University of Lagos, we have to perform our own obligations. On your own part too, as students, you need to perform your own obligations by, you pay school fees, you attend lectures, you write your exams and pass before you are awarded the certificate, as the case may be. You're right. So, but what we're saying is that when you say a contract is void, at the beginning of it, at the time of those offer and acceptance, the time of considering those terms of contract is deemed that they don't exist. Nothing does not exist. Nothing exists at that time at all. You know. So it could be such contracts may involve gross immorality or deliberate attempt to break. There are many of them. Contracts for you know promoting promoting morality. There are cases whereby there's a particular case where the the a landlord, someone was looking for a house. A tenant, potential tenant, came to a landlord looking for a house. The landlord, of course, seek to know what exactly he need to that house for, and the lady said it was meant for prostitution. For prostitution. So the landlord knew and now gave the house to that lady for that purpose. So unfortunately, the market was bad, so the lady could not pay the rent, right? And the landlord now sued for breach of contract. So the question was, that someone is into prostitution, you don't lease that person your own house. Now the person is saying no, there's no customers, so they don't raise the money to pay you rent, and then you go to court to sue that person for breach of contract. So the court were looking at it as okay, you know, you know, um, it was meant for something that's against public policy. You can't go to court and ask the court to take the money from the prostitute and give you. There are also cases that people have supply, clothes, materials, dressing materials to prostitutes on a hire, so that when they do the businesses, they will refund them the the money for those clothes that they've hired, and of course they did not refund, and they've gone to court. So all of those ones, the court have turned them down because of public policy, because doing that prostitution is wanted. So there are many of such cases like that which we come across. You know, mortgage. You can see the case of Savannah Zagilo. A bank was unable to enforce a mortgage for failure to obtain governor's consent. It's a requirement of law, that Land Use Act, that before you pass any interest in land, when you sell land or pass any interest in land, you must obtain governor's consent. So, as a as a mortgagor, that is, if you a banker, you lend money to a customer and you collect the customer's property as collateral. If it's land or landed property, you must, you know, register it and obtain governor's consent. Where there's, forfeiture, you want to forfeit that property because the person did not pay, you want to forfeit it, you must obtain governor's consent before that property will be transferred to you. So if you fail to do that, that will be illegal, and the contract will be void, and of course, not be enforceable as the case may be. So that is one example also of a void contract. Now, the most common one that is available to business people is contract in restraint of trade. You know, so it is a one by which a party restricts his future liberty to carry on his trade, business, or profession in such manner and with such persons as he chooses. You know, so the ideally, as professionals, as employees, as workers, you have the right to work with any person of your choice. But here we are now, you have entered into agreement whereby you got to remember that there is a contract, either the contract, it could be a term or a clause in the contract of employment, or sometimes it could be a contract that is signed separately after you have, signed a contract of employment, whereby the employee will voluntarily agree that in future, that liberty to carry on any profession of your choice is a freedom that's given to every person. But if you choose to restrict that freedom by saying, you know what, because you are working with this company, you will not work with that similar company in future, or you will not carry any similar trade around the premises that that company is also having its businesses, or You not perform that your own business in such a manner or in a similar way as the other your previous employers. If you do that, that amounts to what they call contract in restraint. Restrain. That is to restrain someone from carrying out his own trade or profession or business. So it's voluntary. So you are the one that have done that. So where you stop someone's liberty, because liberty is fundamental to every person. So initially, the law was to the effect that if you sign such agreement, it will be void. In other words, it will not be enforceable because it is against public policy for you to restrain or stop someone from exercising his own liberty, exercising his own freedom, exercising his own right. So initially at common law, in the past, in those years, at the beginning of you know this area of law, such contracts were not enforceable. In other words, you can sign such agreement with your own employer, but still violate it. I mean, disobey it, but nothing will happen to you because the contract is deemed to be void. But the situation have changed now. The situation has changed now. Now, such contracts are no longer void. They're no longer void, meaning that they are enforceable. Just that parties have a restriction, they have a duty to prove that it's enforceable. So by proving that the striking word there is about whether it is reasonable. So if you can stop someone from working with you, if you allege, or if as an employer you don't want someone to work, carry on similar business after leaving your own employment or place of work as case may be. If you don't want that employee to work or carry on that line of business, then you must provide justification, reasonable justification. So if you are able to provide that justification, fine, the court will grant it. And so it will no longer be void as it used to be in the past, because the court will do what? The court will grant it, you know, as the case may be. So, of course, you can also prove that it's not unreasonable to regard to the person that is stopped, or it is not injurious to the public, as the case may be. So, there are cases that are provided there. Leontar Riches and Nigerian Textile Mill Limited. They are all cases that are reported cases where some of the senior employees of the Leontar Riches was the senior employee of a textile mill based in Lagos. So they prohibited him from carrying on the business for a period of 2 years after leaving the employment of the milling company. You know, and he was not to take directly or indirectly any business, you know, from any company competing with the Nigerian Textile Mill Limited, uh, you know, in Nigeria, So of course they have to provide justification. Why do you stop someone that has worked with you? Those things are still happening, whereby you sign an agreement with your employer that you will not work, carry on a similar business with your employer or any of your customer, you will not have cost deal with it, you know, or any trade secret that you come across in the course of employment that you not use it, subsequently, as the case may be. So now, as I say, in the past, such agreement were void, not enforceable, but today they are enforceable. Just that the party that wants to, enforce it, that's the employer. If the employer wants to enforce it, he must provide justification why it is so. And if it is convincing, the court will accept it. And the case of Leon Tourist, the case for instance, with Nigerian textile, for instance, the plaintiff was able to convince the court. I mean, the Nigerian textile mill limited was able to convince the court, and of course, they stopped the plaintiff from carrying on that business within 2 years, as stated in the agreement. So you have to pay attention to some of those things. That's very, 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 very common. It's very common. There are sometimes that some cases that the employer will show that look, oh, the person is in a managerial position. He has known the trade secrets and all of those things. So if you're working, and of course you are in a management position, just watch out. Watch out before you start signing some form that you don't know. In the past, such were avoid because it will promote monopoly, but now they are enforceable. So take note of all of those things. So let me pause here and ask for questions, clarifications.
Good evening, sir.
Yeah. Can you address yourself properly? Barrister who?
Barrister Henry, sir, representing myself.
Okay. Cancel. You're good to go.
Okay, please, I want you to actually touch on that Savannah Bank and Agilo case. I was reading it and I just wanted more understanding about what actually went wrong there, because it's a very common action. I don't think most persons have governor's consent on their landed properties. So maybe you can just give us more insight into that particular case.
When you read it, what did they say? So that the little that you know, then I'll add it from there.
Okay, so it mentioned that Savannah tried selling the the land of Agilo, which Agilo actually placed as part of the mortgage collateral.
Yes,
But
yes.
because Savannah were doing it more like a forceful takeover instead of going through a proper transfer. So Agilo took them to court and argued that the deed was void because it lacked the governor's consent, which was a requirement for a valid land transaction under the Land Use Act.
Yeah.
And the case also went up to the Supreme Court, where the Supreme Court affirmed Agilo's argument that it is a mandatory requirement for the governor's consent to be given for any transaction involving transferring interest in the land.
Yeah. Yeah. So thank you. So that is what the way it is. So now, so you see, the contract there was what? The contract there was, you know, mortgage contract. So you know that illegality can be either at the time of forming the contract or the time of performing the contract. Are we together? So having a mortgage agreement is lawful. Now, but how you can when there's failure to pay the loan, so and you want to execute, that we want to perform that that mortgage agreement, because what mortgage does is that collateral, that property that a bank will collect as security, the owner of the property will state that look, oh, if I fail to pay for the loan, that the bank should take over the property, either manage or sell to recover the loan plus interest. So so you see that it's at the time of performing the contract. So creating a mortgage itself is not a problem. But how you execute terms of that mortgage must also be in a legal manner. So if you look at Savannah Bank, for instance, which is a requirement of law. If you look at Land Use Act, for instance, it's a requirement of law that you it's a must obtain governor's consent before a title is transferred. So what I mean is that as a property that's given to the bank, before the bank will say that you cannot transfer title that you don't have. So the time that bank will have title in that property is when they are able to obtain governor's consent, so that the property now comes to the bank. Then the bank cannot sell to whoever they want to say or manager want to say, so that they can now do what? get recover their money back. So it's a requirement of law. It's a law that says so. So if you not acquire a title by complying with the provision of that law, then it means that you don't have any title to transfer. And that's just the argument. That is what the case was. It's a popular case in land law. Those that are doing land law, it's a popular case in land law. So about title transfer is when you have title in the land that you can transfer, right? So, but in the context of agreement, they're saying that look, for you to exercise the terms of that mortgage agreement, you must follow XYZ, then acquire the title. Then once it becomes yours, you can sell it and call your money. But because they don't follow that procedure and they rush into selling, the owner of property say no, yes, you are not done. The property is still, the title is still with me. You have to follow the due procedure of law to do that. And that's where the issue of forceful sale came in. They didn't follow all those procedures. That's just what happened in that case. The mortgage is legal, but in trying to perform the terms of that mortgage agreement, they follow illegal means. They follow legal means, and that was how Ajudo was able to stop them. Councillor Henry, I don't know whether I've thrown some clarification to your question.
Yes, you have. But I just wanted to say, so who is actually to blame here? Is it that the legal
Is the
team
bank
of
is the bank that
okay,
got it wrong because they
okay.
did not follow the lawful procedure for enforcing a mortgage agreement.
All right,
They
thank you, sir.
they follow shortcuts. They follow shortcuts. I mean, I'll put it in the layman language. Like, they carry shortcuts to enforce the agreement, and the man do not say no. You have to do due process as required by the law, and the Supreme Court say yes. The bank did not follow the due process. That was all. Yes, more questions. I'm expecting more questions. If you don't, then I'll proceed.
So I have a question, sir.
Yes. Address yourself.
Good evening. Good evening, Prof.
Good evening.
My name is Barrister Ernest.
Yes. Barrister who?
Ernest.
Barrister who?
Ernest Ugochukwu.
Okay, Gochuku. Okay.
Yes, sir. So I was somewhere yesterday and I was listening to what those people were discussing. And the discussion was centered to the fact that Mr. A gave Mr. B money to buy an illegal arm for him. So then Mr. B somehow was not able to buy the gun. So and Mr. A is now asking Mr. B to give him back his money, and he said there's no money to give you back. And Mr. A is saying that he's already talking with a lawyer that is going to go to court to be able to retrieve his money. So I was just wondering, I said, is this an illegal or a legal business contract that they did?
What is the subject matter?
Procurement of firearm.
Huh. So is there a legal way of is there, are there some lawful preconditions that
There's no
must meet
there's no lawful
before you
connection.
procure firearms? Are there some
The only
oh you can just go to market and buy firearms and supply? Is that how it's done in Nigeria? No, but that's what you should know now. Because when they say something illegal, it means that the law
you
prohibits,
know,
or the law limits what
such
you do. So you need to follow that. Once
yes.
you follow it, so you are saying that anybody can go to market and just buy firearms
Uh,
and just start
uh,
selling
uh,
it. So you are a senior. Do you know you are a very senior counsel? You know.
yes, sir.
You are a very senior counsel. You're supposed to advise them. What is the subject matter? So once you see subject
I've
matter, you don't ask yourself what the law say about this subject matter. If you want to deal with firearms, go and obtain license. There's no two words about that. So the first thing
exactly.
is like you are saying you are a bank, that you will sit in your house, say you are a banker. You are like UBA. They will ask you, say you are UBA, bring your
Li-
license, bring
Of
CBN
course,
license.
I said yes.
So once you don't have them, means that you are illegality, and law will not, the law cannot help you. So the person has to go back and obtain the license, and then regularize the agreement as if the relationship, as if they had the license, and initiate a new something, because the license will have a date, and then the time that you also enter into the agreement will also be there. So you have to first of all obtain the license. Otherwise, it's a bunch of illegalities. I've given you advice. Take it to them. Let them give you your money
Thank you,
as a
sir.
counsel. Let them give you your money for for
Thank you, sir.
consultancy. Consultancy, yes. Yes. More questions. Is the class governor in this class? Chinelo Banafo. Is she in this class?
Yes, sir.
Okay. I want to be sure. So that someone know you see your name. So if you don't have any other question, I proceed to the next thing we need to do, which is discharge of contract. Discharge of contracts. That contract has come to an end. For everything that has a beginning must have an end. For those of you that are doing MBA, you started MBA, you must end MBA. You can't remain doing MBA forever. I remember those days as some people that will, every year you ask them they're in school. Every year. Huh? Worried. This person cannot finish school. So don't be typed that anywhere, every time your colleague in the office asking you, don't you know that I'm doing MBA in Universal Lagos? Every time. So you will not finish. Uh, Finish all. Right. So everything that has a beginning must have an end. So you have what they call the various ways by which a contract also comes to an end. An agreement will come to an end. So once an agreement has been brought to an end, the there- there's no relationship again subsisting between the parties. Once you read the first paragraph there, can someone read the first paragraph there?
A contract is discharged when the contract is brought to an end and the parties are freed from their mutual obligations. A contract may be discharged in four ways: by performance, by agreement, by frustration, and by breach.
Okay. So before I proceed, we had also looked at ways by which an offer can be discharged, ways by which an offer can come to an end, and ways by which a contract can come to an end. The two of them are different. An offer and contract are different. We also look at termination of an offer. We're also looking at termination of a contract. So what's the difference? What are those ways by which an offer can also be terminated? And are they the same with termination of an of an of a contract? Can you hear my question? Hello.
By death
Yes,
of
sir.
the offerer or of Paris.
Okay. That's Barisa who? Barisa who? Precious Agu. Okay. So mention them. Yes. Let's hear you say date of who?
By death of the offerer or Farid.
That's correct. That's number one. Deborah is
Can also
saying, yeah, go on, go on.
by expiration of contract,
Respiration, yes.
by frustration,
No.
then by okay. At least okay, I've tried.
You are not the only lawyer in town. So you try. You are not there are many lawyers in the house. So they should also take the aspect of the judgment. I mean of the trial. So this yeah, someone there, Manuel, someone saying rejection, there's revocation, and all of those ones. Yes. Deborah, lapse of time, rejection, revocation. Yes, correct. So you see that I'm asking that because in exam, don't make mistake of if they ask you ways by which because student make that kind of mistake, ways by which an offer may be discharged. Then they'll write to you ways by which a contract will be discharged. They are not the same. An offer per se cannot be from a contract unless that offer is accepted. Other terms are also present before you can create a contract. So you have to watch out because the two are not the same at all. And the terms of that contract are carried out. That's the end of it. So even that admission letter, the contract between you and University of Lagos has come to an end. You will not be asking to that they should pay you school fees, or they will be asking me to come and be teaching you every Thursday again because that contract is deemed to have come to an end, right? Now, but the question is that, or the issue is that, as a general rule, the contract has been performance has to be total, complete, exactly. So if the terms of the contract are A, B, C, D, then you must perform A, B, C, D because that is what is required. But then there are exceptions where even though the terms of the contract, the performance of the terms of the contract is not exactly as stipulated in the contract, yet the uh, contractual relationship is deemed to come to an end. And so we have those exceptions there: substantial performance, several contracts, and probation of performance. So you have situation whereby that's for those of you that participate in elections. You know, elections are conducted, and you say that you know, there was no compliance with electoral act or electoral laws. But if not INEC will just come and say no, there was substantial compliance. So what I mean is that I'm not saying that everything that went on in the election was as stipulated in the law. No, but substantially there was compliance. So even in contracts, there could be instances whereby you know not all the terms of the contract are complied with exactly as stipulated in the agreement, but then there's substantial compliance. You know, so assuming that someone was hired to construct some office spaces for you, a duplex or plaza for you. The person did you know all that was stated in that building agreement, and only left what was remaining is just socket, maybe socket in one or two offices. You see that it may not be exactly as done, but there's substantial compliance. also building contract. A contract for building has several contracts involved, and that's why payment is barely the first floor. They'll pay you second floor. So you see that most instances where you cannot pay all of those, pay for the next part of it. You see abandoned project, abandoned project. Which government, most of this government, part of government, you have heard so much about abandoned projects when it comes to government, because of what? Because they did not to uh, uh, they did not to you know um, they didn't. There are several part of the contract, and you can't always hold someone back for the next, milestone that you fail to, or where it is the other person who's supposed to benefit from the performance that stop you from performing that contract. So if you stop someone from performing a contract, you cannot come back again and claim that that you did not perform it. So that is just number one. Number two, yeah, someone can read the case of Qatar and Power. You can check that on online. Can someone read the case, the facts of what happened in Qatar and Power? Yes, yes, yes.
So I want to ask a question.
Go ahead.
So in case of substantial performance, is it not a bit, should I, for lack of words, use, like flexible? Like, doesn't it create opportunities uh for the other party in the contract to not perform completely, knowing that that clause may apply to him? Oh, like you mentioned in the case of the house, and maybe the person did not put sockets in maybe one or two places, so that's fine. Person perform, but not completely. It doesn't it give opportunity to uh avoid like implications of not fulfilling. I just like end to end. Is the contract not supposed to be fulfilled end to end?
Hello. Can someone hear me?
We can hear you, sir.
Yes, I can hear you, sir.
Who was asking the question?
Yes, sir, can you hear
Hello.
me now? I don't know whether I'm the one having it.
You lost the network, or is it from my end? I wasn't. I just couldn't hear what the remaining part of your. But you said that someone you were saying is
Yes,
about.
but can you hear me now?
Yes, yes, yes.
Yes, I was saying that this substantial performance exemption clause, so to speak, does it not allow for does it not allow for non-complete performance? Like, does it not give opportunity for the contract not to be fulfilled end to end?
No, no. So
Because
what
I
happens
thought
that what?
lawyers are enforcers of.
Yeah, no, you are. So that's where the issue of remedies comes in. So instead of rejecting the contract completely, you accept, and then you now seek remedy for the part that is unperformed. So if the socket that's left, so just for you to ask for remedy is to money for the amount, or you can, if you are to pay, you can just do set off, pay the person less than those sockets that are remaining. That is also just that the law allows you to seek compensation for that part that is um undone.
Oh, okay, I get it now.
Yeah, exactly. So you are to pay the person for what the person have done. Not as if you pay the person for everything including the one that did not do. No, you pay for what the person have done, and then if you have paid the person before, you can seek compensation for the balance of, for the one that is left undone.
All right, sir.
Okay. So the other one here is discharge by agreement. Contract is by agreement. Contract, two minds comes together only by way of agreement. So just as two parties come together by way of agreement, so also they can agree not to perform, just forget their rights, that the right they have they created under the contract. They'll come together and agree that, you know what, we're not going to perform this thing again. Just you go your way and I go my way. Typically in contract of marriage, where a couple are seeking divorce, they say, you know what, we can't stay together again. You go your way, I go my way. Simple as that. So you also have the there are many ways where such in the normal agreement, there are sometimes that parties may, you know, enter into new terms or transfer the obligation to another party entirely and step out of it. So all of them, there are many ways. And the beauty of it is that in most contract will state in the contract itself how it may be terminated. So where the contract states itself on how it may be terminated, all you need to do is just to uh, all you need to do is just to um, go by the terms of that contract in terminating that relationship, right? That's it. So the third way of discharging a contract is by breach. Breach. Can someone read the first paragraph? Can someone read the first paragraph?
Discharge by breach. A breach of contract occurs when one party fails to perform his obligation, either totally by refusing to perform at all, or partially where his performance is defective in some ways. Do I go ahead?
No, that's
Anticipatory.
fine. Okay, so the essence of coming into agreement is to perform obligations. That is the whole essence. Parties are bound to perform their obligations. And that's why the terms of contract will state what each party is to do. So when as it is. So if I still come back to University of Lagos, for instance, send me to come and perform the part of obligation by having lectures with you. So no matter how tight, I must create time to have the lectures to perform on the side of. So if I fail to do that, that will amount to breach of contract, and you can sue University of Lagos. As simple as that. Right? Now, so just have that in mind that when there's a breach, when you fail to perform a contract as agreed, then of course it amounts to a breach of contracts. If you perform those contracts, it means that it will terminate by performance. Where you perform the terms of the contract, it means that that agreement will terminate itself by performance. So essentially, there's this aspect of there are two types of breach. You have the actual breach and anticipatory breach. So you have situation whereby you can prove that contract for supply of clearance of goods or importation of goods or hiring of selling of office space, warehouse, you know, and you took money, you didn't give the person the office space, you didn't clear those goods, you didn't perform your obligation. That's actual breach. Now, it could be also, that's I'm talking about anticipatory breach now. It could also happen that it occurs where when there's a contract between two parties, that's number one, to be performed at a future date. So remember that at the beginning of the lectures, I gave you when I was doing classification of contract, I said one type of contract or one classification of contract is executed and executory contract. And I said that executed contract is that contract which you enter into and you perform immediately. So if you go to a restaurant to buy food, you pay for the food, they give you food, you ate. That's executed. Or you go to computer village, you pay for your phone, they gave you your phone, you left, executed immediately. You go to a supermarket, pick items, pay for them, they give you those items, executed immediately. But there are some contracts that are executory. There are some contracts that you enter into, but but actual performance will be in future. So it could be a contract for events, managing events. It could be a contract for anchoring event or MC or performance, contract for building. You can sign a contract for building on your mansion, but that mansion cannot build at that moment after you pay for it. It will take time before the construction is completed. So that means that it will be done in future. So anticipatory breach falls under executory contract. That's those contract that performance of it is in future. You pay for the goods, but they say they will supply you those goods in 2 weeks' time. Like between you and University of Lagos, what you pay, the school fees you pay is for MBA certificate. But then you have that certificate itself. It will be in future that they will give you, not now. Now, so anticipatory breach comes in where the contract is executory. That is to be performed in future. So what happened here is that if one of the parties have shown either by words or action that he has no intention of performing his own side when that time arises, then it amounts to anticipatory breach. So that means that date for the performance of that contract has not arise. But going by the words or action of that person, it shows that you will not perform that contract. There are many examples. Someone is coming to perform at your son's birthday tomorrow, and you heard the person telling someone that local is traveling to Germany tomorrow this night and is to perform at your event, your son's birthday tomorrow morning. You heard him telling someone, you know, oh, you know that the person is already at the airport, so you know that tomorrow is tomorrow. You have not reached tomorrow yet, but the fact that this person traveling outside the country today clearly shows that that person will not be available tomorrow to perform his own obligation under that contract. You know, a company are taking money from you to perform a particular obligation, and you hear that this company is going into distress, financial distress, into liquidation. They already filed petition for winding up. Where on earth will that company get any this to perform its obligations? Right. So in such cases, so what I mean is that even when you enter into a contract with somebody, and if that contract is such of the nature that it will perform in future, you don't need to wait till that time. You don't need to wait till that time. But once you are able to observe, either by words or by conduct of that person, that that party is not going to perform, is not likely to perform that contract, then it is what they call anticipatory breach. So a party can sue, you can have the right to sue, you can take action to sue, notwithstanding the fact that the time for the performance of that contract have not arisen. You can sue for that alone. Right. So, but then if they sue you for anticipatory breach, that person, that guilty party that by his words or conduct, may also have a defense. You have a defense where there are circumstances that will prevent you from not carrying out your own, obligation, or what they call lawful excuse. There are some excuses that are lawful that a guilty party can take. For instance, where someone is sick. So it's not as if you will do it, but just like you can't do it that day, because if the sickness still continue after the contract has been signed, how will you perform? You know. That's why even in contract employment you have what they call sick leave. When you are sick, you are excused from carrying on your own obligations. When you are fine, you come back. So the fact that they hear that someone is sick does not mean that you not perform. You perform. So when they say supervening circumstance or event that will justify why you will not be able to perform that contract in future, then that will amount to lawful excuse. As the case may be. Yeah. So let me pause also here and ask questions. Do you have any question on this?
Sir, good
So I
evening, sir.
wanted to ask,
Yes, Ugochukwu.
Okay, sir. My question is this, sir. If, like the example you gave, if you heard there's an anticipatory breach, that somebody is going to carry out an anticipatory breach of the contract you have with him, but you don't have a concrete evidence to present before the court, how do you
You lose.
go about it, sir?
He who alleged must prove. That is just the law. The law is simple, very straightforward about that. He who alleged must prove.
Okay.
So if you don't have evidence bad for you, you're on your own. So you have to wait till that day. If the person did not perform, then you cannot sue the person for actual breach.
Okay.
Yes, the other counsel that wanted to say something, a lady.
yeah, my question is quite similar to his. I wanted to ask,
Your voice has gone. Barrister Emo, Precious. Your voice is gone. We can't hear you. Can someone hear me? Can you hear me?
Yes, sir. I can hear you, sir.
Okay, so she's the one that's having network issues then.
Yes, sir.
Okay. So any other question? Okay, so if there's no question, let's proceed. So the next one here is discharge by frustration. You know, so this one too, very important. And I want someone to read it. The last paragraph.
Risa, I, Barrister Julius Obafemi, discharged by frustration. Parties to a contract are discharged, in bracket, excuse from further performance of their obligations if some unexpected events occur during the currency of the contract during the currency of the contract without the fault of either party, which make further performance impossible or illegal.
So here also, one way that a contract may be discharged is where parties to a contract, they enter into a contract, but before they carry out the obligation, or one of them will carry out an obligation, an unexpected event occur, and because of that event, it becomes impossible to perform that contract. So if you can segment it, you can segment it. Parties have entered into a contract. You know, but before they will carry out their obligations, unexpected event occur. We thought the fault, it wasn't the fault of either party, but that event has occurred. But because of that event, it becomes impossible to perform that contract. That is what is called frustration. So frustration in contract different from when you say I'm frustrated. When money is not coming the way you want, you are frustrated. Someone is appointing you, I'm frustrated. No, that's not what we're talking about here in terms of contracts. Or when you are finding difficult to do something, you can't do fast. That is not it at all. So
Sir,
here
sir,
is,
sorry, sir.
go ahead.
Does it invalidate the contract then?
No, it brings that
Okay.
contract to an end. It brings the contract to an end. Not invalidate. The contract is still valid because as we're going to see, if you are
Yes.
carrying out your obligations, if one party have carried his obligation before that frustrating event occur, then that person will be entitled to the benefit of what he has done so far. But any other subsequent
Okay.
obligation, any other subsequent obligation will be suspended. So when that event occur, you ask the question: has any of the parties taken step or incur losses, or none of them have started? Have not started anything. If none of them have not started anything, no one is responsible for anything because at that moment all the rights and obligations of the parties stand, discharged. You are not accountable to any person again because of that event. So there are many of such events. It could be enactment of law. You want to go into a contract for importation of or clearance of drugs or or objects at the port, and federal government have introduced a law banning the operation of the sale or transaction in such goods or property or drugs in Nigeria. So it's not your fault. It's not the fault of any of you. But then you can't deal with that property again because of the new law that has been enacted. What about ASU strike between you and University of Lagos, MBA program, and they start to strike for years? What can you do? It's not the fault of university. It's not the fault of the student. But you can't have lectures. You can't go on. You can't. There's no way that you sue. So the program that you were supposed to do for 1 year, you will end up doing for 2 years or 3 years. You cannot sue the university because it's not the fault of the university. It's not the fault of the student. It can be war. It can be protest. You are supposed to report to the bank or go to work as a banker, as a bank manager, but you woke up, there's protest all over the area. You can't resume to work. It's not the fault of the banker. It's not the fault of the fault of the staff. But you can't just work. So it could be flood. Flood just taken over your office, flooded everywhere. You can't go to work because of the flood. So it could be fire that will destroy the property. So it could that's what we're saying, that event is not the fault of the parties, but you can't just do anything. It could be out of God. It could be man-made, like enacting a law or prohibiting parties from dealing with such transaction. So any of such terms could be, amount to what? Frustration. Even debt. Sometimes they give debt as one of the example of frustration because you enter into a contract before you perform. One of the parties have died, So, and of course, the question there is that death is not, you able know is going to die, but you don't know when, but not as if you wish that you die because you enter into that contract. So a contract of personal nature always goes down once the death itself occurred. Right? So the instances where contract has been frustrated, illegal performance of the contract, destruction of subject matter, either by fire or flood or anything, where the whole base of the contract is the occurrence of event which does not occur. You hire a building for to watch the coronation of the president or chief or king in your place, and they suspend the coronation or the installation of the king. Nothing can happen. Now, what to deal with is the consequences of it. What could be the consequences? So once frustrating event comes, happen, the contract comes to an end automatically. Now, as I say, it's only for future obligations only. If some obligation has already been done, the party will get benefit to work for what they have done before the frustration event. So it's only that part that is in future and has been cut off by that frustrating event that is not enforceable because the contract is deemed to come to an end. So this is what this you can see Chandler versus Webster and Fibrosa cases also there for you to Fairborn, Lawson, and all of those cases there. Fibrosa's case. Yeah. Yes, once we Google Fibrosa's case so that I can just read it briefly. And also there's room for questions for those that want to ask questions. You can ask questions. Hello, are we together?
Discharge. This is Precious reading.
Oh, great.
Instances where contracts have been frustrated. Illegal
Is that
performance
Fibrosa
of the
case?
contract.
Is that the Fibrosa case?
Okay, no, okay. So you need to change your screen then. Fibrosa case is the last line there.
Okay, so you cannot see it.
No, you need to change your slide, the next slide.
I can see it.
Just
Yeah.
type Fibrosa case on your device. Fibrosa is Fair Bend. It's a popular case. Have you seen it?
Yes, sir.
And okay, so someone should read it. What happened in the case?
So the case Fibrosa versus SA versus Fairbairn Lawson Kumbe Babo Limited.
Yeah.
So it's an English company that's Fibrosa agreed to sell to the Polish company Fairbairn Lawson Babo Limited a machinery for £4,800. And of the £4,800, 1/3 of this was to be paid with the order. There was a deadline given for the delivery of the machinery that was ordered by the Polish company at 3 to 4 months. after the settlement of the final detail. So there was a particular clause in a term in contract that required Fibrosa to arrange that the delivery of the machinery be done by sea to Poland, and it was subject to some terms and conditions, part of which contained in the contract document clause 7. It provided that the company gives a reasonable extension of the delivery deadline, which was initially 3 to 4 months, in case of certain hindrances to the dispatch of the goods due to maybe war or any other cause beyond the control of the English company. And for doing that, the Polish company, which is Fairbairn, paid only 1,000 from the required 1,600 deposits, which is 1/3 of the price. And then on September 1st, 1939, a war broke out between Germany and Poland, and the Great Britain declared a war on Germany. So as a result, that sea transportation through which Poland, we should have gotten to Poland, was occupied by the Germans, and the English company decided not to dispatch the goods. So Fibrosa did not dispatch the goods. And then the Fairbairn wanted to recover the £1,000 they paid as deposits. However, the Court of Appeal ruled in favor of the English company, Fibrosa, and the case was escalated to the House of Lords. And the appeal was allowed because the clause that was given was limited only to a delay in respect of which a reasonable extension was granted. So the war was not such a delay that's from the outcome, because it involved prolonged and indefinite interruption to the performance of the contracts. And also there was also a failure of consideration under the contract, because the payments received was 1,000 deposits, and it was not absolute, but a conditional payment on account of the purchase price.
Okay, thank you so much. So you will see that in that scenario, what was the supervening circumstance that made him not to perform the? What is that event that happened?
There was a war.
War, exactly. So see, that is just the point I want you to take home as well. That war, the war wasn't the fault of the parties, but because of that war, it became impossible for them to perform the contract. So war is also one of the examples of the events that we're talking about here. Okay, so now we go to remedies. So when there's breach of contract, of course, you know that if a contract is terminated by performance, no issue at all. If it's by agreement, the parties will say, okay, you know what, you do this, you do that. Because it's when there's breach, by way of breaching, when there's no compliance with the terms of the contract, either actual breach or so remedy, of course, the issue is that what is the nature of remedy. So our remedies, you have different types of remedies. Some that are common law remedy, which is only one. The common law remedy is damages compensation for the injured party. You know, it may be. I didn't understand that. It may be evaluated or quantified or unquantified damages. You know, where it is quantified, it means that the value of what is paid as compensation is known. But where it is general damages, you know, what they call specific and general damages. Where the specific one, you know, can be pleaded, and you also know that this is what you can't really place it. For instance, someone is owing you 100 million. You don't use other resources. You do, you know, you're going to pursue that person. You hire a lawyer. You go, you for your car. You know, all of those things. Those can be general. Like add to the main one, which is 100 million, and the So you can, when you are saying you are looking for damages, you are looking for compensation for what the person did not, you know, did not do. So why I'm discussing this topic, please, you people should go on and also research for Hadley and Bazender. We're coming to it. I'll ask you a case about that too. Hadley and Bazender, very interesting case about remedy. So at common law, of course, common law is about fairness, equities. You have other remedies like restitution. You have remedies like specific performance, whereby you don't want compensation. Instead, you want that the party to go back and perform the terms of that contract as it were, or injunction. Imagine someone is to perform your own contract and you hear that you want to move that way, want to assign that office space to somebody. You can go to court and get injunction stopping that person from giving that property or that office space to someone else, or moving away from the jurisdiction of the jurisdiction of the court, as the case, may be. So those are equitable remedies. But the one that is major one is the damages, which we're going to look at. So there are many rules of damaging. One of which is that it must not be remote. That is the action or inaction that will lead to the claim of compensation must be closely linked. It should not be a distance. That factor should not be a far distance. So let me give this example. Of maybe this is being law of thought. Maybe warehouse. You have imported some goods. They are proper think tank, and then you think tank, and then you are supposed to pay money for someone for a warehouse. Now that warehouse, was delayed. Because of that delay, those goods are also, you could not clear your goods, take your goods at the airport, from the port on time, and then they enter demurrage. And because of demurrage, the profit that you would have earned because of that delay, you could not, because there's something. Now the question is that what exactly would have led to the loss of the profit? Is it the delay in the handover of the warehouse to you, or the demurrage that incurred at the port? Which one is the direct consequence of loss of that profit? What could be? Hello, class. Hello.
Yes, sir.
Yes, sir.
So what could be the direct cause of there's what they call direct and remote cause. Yes, yes, yes. So can you hear me at all? People are not
We can hear you,
responding,
sir.
so I'm wondering whether you are hearing me.
We can hear you, sir. The
So when I
direct
ask a
cause could
question,
be, sir, the direct cause
but
could be
when
the,
I ask a question, nobody's, eh?
okay, sir. The direct cause could be the demurrage at the ports. That's the direct cause. The warehouse not being handed over could be a remote cause.
Okay, so but the point I want to know is that in contract, when you're talking about damages, that you pay damages, you must find out whether what you are claiming under that contract as damages, the loss or that you're seeking compensation flows from the contract. It doesn't flow from the contract, then you cannot get compensation. You cannot get remedy. So remoteness is when the cost is very far, not closely linked. And of course, um, where it's too remote, then of course you cannot get compensated, as the case may be. Now, this case of Hadley and Bezende, of course, to tell you exactly, what play out. So at least someone should read this case. Yeah, someone that have researched about this. Can someone read the case out?
Yes, sir. Good evening, sir. So,
Yes, Cancer, go ahead.
yes, this case is about Hadley, who owned a flour mill, and while during production, his crankshaft
the mill's crankshaft broke and he had stopped operation. So he hired Bazendale to transport this broken crankshaft to the manufacturer for repairs, and Bazendale delayed the delivery. So this caused Hadley to shut down his plant for a while, which led to loss of profits and production and profits. So he sued Bazendale, and the
Hello,
court ruled in
I can't
favor.
hear you again.
Hello, sir.
I can hear you now.
Okay, so he sued Bazendale, and the court ruled in favor of Bazendale because they said Bazendale was not liable for the loss of profit because he was not informed that his delay would cause loss of business.
Okay, so you see that there was loss because of the so the court was very overlooked. But if there was if the factor of delay was contained in the terms of the contract, then of course it would have been useful. But we see that here, that factor was not there, and that's why it was not useful, as the case may be. So it's very important that you should take note of all of those things. So,
So
um,
I want to ask that even though it's obvious that this delay was obviously going to affect Hadley's milk plants, and is it because it wasn't actually stated in clear terms, even though we are like stating the obvious, like you are obviously affecting my business, only because
yeah,
it was not stated in that in the contract, then it's not useful.
so that's what the court was saying. So it's a question of fact and circumstances. So in this case, for instance, now the court weighed the fact that that company had option of informing this person that, look, if we delay, this is what will be the consequences. So they will now decide on whether they want to do that or not. That's one. Secondly, they also had an option of buying a new one, improvising for new one, but they didn't do that. In fact, the court also raised the issue of mitigation of, as we're going to say, mitigation of damages. That when there's a breach of contract and losses are to be incurred, and you are in a position to mitigate the losses, then and you failed, then the court will not help you. You know, like contract of insurance, for example, your car, you insure your car against fire or accident. Yet you still have to go about with fire extinguisher. Like if the car caught fire, you must attempt to use fire extinguisher to stop the light, even though you would insure the car against fire or things like that. So you must make effort to mitigate. So the court was saying that, look, can you contemplate that because someone delayed transporting this in? Was there anything in contemplation to show that, look, that will lead to delay in your sales for not making profit? And how do we even conclude that once you sell, you once you produce, you must sell in that volume that you are. So everything was just being estimated, because the fact that you manufacture does not mean that you actually make those sales. So there are many things that the court took into account to come to that conclusion that it wasn't reasonably contemplated in the agreement. That was also what the court had. But as I said, all of these are question of facts and circumstances in each case. Hello, any question? Any other question? So on measurement of damages, as I said before, the aim of awarding damages is to compensate, not to punish the wrongdoer. So the loss of damage is a yardstick for awarding loss of again is yardstick for awarding damages. So, but the problem is that, look, because someone has breached a contract, it doesn't mean that you punish that person. No, it's not meant to compensate. And so a party has to take steps to mitigate the loss. If you can Google any of those cases there, I'll give you the same thing that, look, you must take steps to mitigate the loss. You can't just fold your arms and say that, oh, By the way, it's obligation on the other party. He's one that failed to do it, so you will not that can't help. Because you have a security man, you left your car unlocked. So that, by the way, it's not you own this. The security man is the one in charge of it and all of those ones. Cannot help at all. So at the same time, in the last paragraph there, why the plaintiff is under the duty to take legal step to mitigate the cost of breach. Such you can also when it's unreasonable, you can't take unreasonable step. Of course, because you want to mitigate the loss, you want to jump into a house because the house is caught fire. You have insurance cover over it. Because they say that you should mitigate loss by taking items from the house. The flame is high. You want to jump into the flame and bring those items back. That would be a waste of time. That would be unreasonable steps. That cannot help at all. So you can always have a defender look, even though the law says that you should take steps to mitigate the loss. Where those steps are unreasonable or expose you to danger or risk, you are not allowed to take. So how to balance all of those things. Then of course we also have the feeling that is non-pecuniary, damages. The one that we discuss are compensation, monetary compensation, losses. When you lost a building, a car, goods, all of those ones, is monetary. But then there are what they call non-monetary or non-pecuniary losses. So two things here. Under the old rule, if a breach of contract will lead to injury to your feeling, mental distress, annoyance, loss of reputation, and all of those ones, under the old law, you cannot sue anybody on for that under law of contract. But you can only sue that person for law of torts. That was the old law. Now, but then that law has changed now. The law has changed now. So if there's a breach of contract for supply, someone was saying that look, you are working in a place of work and you're someone that hates you in the office, alleged that you stole something in the office when you are not the one. And because of that, they query you in the office or terminate your appointment, with the case may be. It can create some mental, all of those ones, when in fact it's quite that you are not, those things were not, there's no amount of compensation that they will give you that will clear, but your reputation, you can sue, you can also take action where you have mental distress, where you have bad feelings, where you have annoyance, where you have loss of reputation, and all of those ones as a result of breach of contract, right? You have staff working with you. You have to supply some goods somewhere. The staff now, debt with you. They did not live up to expectation, and because of that, the breach of contract. Your reputation is questionable. You can always sue the person that breach that contract with you for remedy for damages. Under law of contracts. But in the past, this was not the case. It was only available for law of torts. But now they are all available. So, ladies and gentlemen, do you have questions? So if you don't have questions, that brings to an end our discussion on law of contract today. We have looked at factors that can, void or destroy a valid contract, illegal and void contracts. Look at termination of contracts and look at remedies that are available, particularly damages, compensation that are available for a party where there's a breach of contract. Both pecuniary losses and non-pecuniary losses, we'll try to highlight them for your benefit. And so that brings to an end our discussion on law of contracts. Any question?
I don't know why. I don't know why lawyers. It's like the way everything is as if let's just go and look for where there's problem or where there's no problem and just start fighting.
Paladeo. Why do you say so?
Yeah, because look at this peculiar I mean
Non-peculiar
it's
loss.
yeah, like it feels like there's even still there are still more that have not been identified that can be added to it. But
Okay. Oh.
yeah, because now the way everybody just says mental health, mental stress, mental this one, mental that one, like it's just and then there'll be one lawyer that'll be willing to take it up in the court of law to say if we can fight it, we can win it. Meanwhile, I don't know. It's just a lot sharp or just feels like you just where there's any opportunity to just prove somebody can be sued. Go to court.
Suing and counter suing. Chineke.
Paladeo. So you can't say you don't know you are a lawyer now, so I don't know.
I have many people in my stream I want to sue.
What are you claiming? Is it mental distress or
There's
just based
now
on
this particular one that you have taught us today. This pecuniary
no
loss,
peculiar losses?
yeah, none, yes, they are disturbing. I have many cases
Mental
now.
feelings.
Yeah, I have
I beg
many
you.
cases.
Easy, also. Take it easy. Oh. All right. So, all right. As I said, if there's no further question, cancer, take it easy. Don't worry. We'll sort it out. That's why you are a lawyer. Huh?
Okay,
So, yes. So, if there are no questions, that's an end. So we'll take it from there in the subsequent classes. All
Thank you so
right.
much.
Yeah. Enjoy your evening. Yes.
Thank you, sir. Bye.
Yeah. Well,
Good
yes.
night, sir.
Una, yes.
You know, sir.
Una, yeah.